5, 4, 3, 2, 1.
Good morning, everyone. Thank you for taking time out of your schedules to meet with us this morning at the June 9 a.m. edition of the meeting of the Advisory Commission on the Rules of Practice and Procedures. And before we get started, I want to go ahead and welcome a few new members that I do not believe we've had the chance to welcome yet this year. First, we've got Judge Jennifer Smith on with us this morning, obviously here from Nashville, Davidson County. Welcome, Judge Smith, and thank you for being here. Also, my old tennis buddy, Donald Caparella, recently was appointed, effective this year, by the Supreme Court to the Advisory Commission. Welcome, Donald. Good to have you here as well.
Thank you.
And then Sarah Keith, coming to us from Clinton, Tennessee, also a new appointee this year from the Supreme Court. Sarah, welcome to you as well. Let me, if I could, turn first to Justice Lee and see whether, Justice Lee, you have any thoughts or comments you'd like to share with the group before we get started this morning.
I was just looking at the screen. This is such a great group. I'm so impressed with all of you. We've got the pick of the litter here for this Rules Commission, and I really appreciate your service. I know it's a lot of hard work. It can be tedious at times, but it's really important, and y'all do a really good job. Thank you.
You're most welcome, Justice Lee, and obviously thank you for all the work you've done in bringing this group together so we can do all this good work for the citizens of the state of Tennessee.
Thank you.
Do we have any other members of the judiciary on who'd like to express any comments or share any thoughts with us before we get started?
This is William Cole. I have no comments, but I promise not to stir the pot too much.
Thank you, Chancellor Cole. We appreciate that. Lynn, why don't we go ahead and take our roll, and then we will go ahead and get started.
Well, good morning. I marked some of you present as you were joining the Zoom. So if I don't mention your name, that means I've counted you as being present today. If I call your name and you're on the Zoom, please just let me know. Wayne Ritchie.
Here, good morning.
Good morning. That's my cell phone number. Awesome. Thank you. Judge McMullen. Aaron Hall. Judge McGee. Jim Bowman. Gino, we have a quorum with those members present. We do.
Thank you, Lynn. Our first order of business then will to consider and approve minutes of our past two meetings, the meeting in December of 2022 and in March of this year, March 2023. Lynn has obviously circulated the minutes with the agenda. Do I have a motion for consideration and adoption of the minutes?
William Lambert here. I'll make a motion to adopt both.
Thank
I'll
you, General Lambert.
second.
Thank you, General Bloomstein. Any discussion? All in favor of approval of the minutes as distributed by the reporter signify by saying aye.
Aye.
Any opposed signify by saying nay. All right, the minutes, Lynn, from both meetings are unanimously approved. Our first action item is the consideration of proposed amendments to Rule 43.01 of the Tennessee Rules of Civil Procedure, and that discussion will be led by Mark Folks. But before I turn it over to Mark, I just wanted to make a comment that I was actually in a bench trial earlier this week in Nashville in Chancery Court Part 2, and we actually had this specific issue come up. A defendant made a motion under Rule 43.01 to allow a non-party witness to testify via Zoom from Connecticut. And the chancellor in that case went through an analysis of Rule 43.01, ultimately decided not to allow the witness to testify remotely, but having the clarification and specificity of this proposed rule would have been invaluable in aiding that discussion. So this is a real live issue that I'm sure is coming up, not just in my practice, but obviously with all of you across the state. So Mark, could you just lead us through a discussion of the current state of our proposed amendment to Rule 43.01?
Yes, good morning. So,
Morning.
I'm trying to recall exactly where we were because I missed the last meeting where I think we ended up without a quorum anyway, and no action was taken at that time. So the meeting before that, my subcommittee presented the proposal that is now before the commission to address issues related to testimony and other things by remote witnesses. We compiled this, and I'll address it a little bit more since we do have some new members. We compiled the rule basically by reviewing several other states that had very, very comprehensive rules. And we took on the parts that we felt would best serve Tennessee and put the rule that you have before you together. At the previous meeting, as I said, which I guess would have been 2 meetings ago, we presented that rule to the commission, and there were several suggestions, I think ranging, as I recall, from just clerical errors or clerical corrections or minor edits to, I think, some things a little more substantive. We took notes on all of the things that were suggested at the time, went back and revised the proposed rule. And so now it is back before the commission again, having incorporated all of the requested revisions by the commission.
All right, and with that background, I will entertain a motion for adoption of the proposed amendment as revised from our last meeting of consideration of the proposed amendment in December.
So on behalf of my subcommittee, I will make that motion.
Do we have a second?
I will second, Chairman.
Great, thank you. All right, any further discussion or comments on the motion and the proposed rule as revised?
This is Jeff Sager. I have just 2 very minor comments on subpart A. The last couple of lines where it talks about testimony in open court by contemporaneous audiovisual transmission, and then it says from a different location using simultaneous audio-visual transmission. And those seem duplicative to me. Maybe there is a distinction, but I'm not sure what the intent was.
Mark, is that something you can address?
I'm trying, what part of the rule was that again, Jim?
This is subpart A. It's the last 2 lines. Where it uses contemporaneous audio visual transmission, and in the next line, simultaneous audio visual transmission. It just looks duplicative to me.
I'm not sure. I'm having a little trouble finding it in my rule. I mean, we did not intend for anything to be duplicative. It's 4301
A.
Mark,
Oh,
if I could
okay.
help it, right at the very beginning.
Oh, at the
of
beginning.
rule.
I'm sorry, I had fast forward to part B. Well, I think I think maybe that is duplicative as I'm reading it. We did take one. We also had telephonic transmission equipment in the rule. We took that one.
And that was removed. Yeah.
Right. So.
I mean, it seems to me it could just stop at after from a different location.
I think that is a legitimate point as I'm sitting here reading it now.
I'm wondering if it's intended to suggest that both locations need to have the same type of equipment.
Yeah, I think that may be it, and that's a good point, Tim, is that you're in open court with contemporaneous audio visual transmission, and then the other person is from a different location using simultaneous audio visual
Okay.
transmission.
And let me also point out, Jeff, this is Gino, that simultaneous audio visual transmission equipment is actually one of the defined terms later on in the rule. And I think there is a distinction between the equipment as defined and just the concept of contemporaneous audio visual transmission. So I think the rule read completely in context eliminates any perceived duplication at the very beginning.
That makes sense to me. And the only really minor point is audio visual is hyphenated in one place and not anywhere else and not in the next. And I think the rest of the rule hyphenates it. So that's just a wordsmithing thing.
That's something that our Cracker Jack reporter picks up every time. So before we actually go to publication.
Yeah, that's a cleanup item.
That makes sense.
That's a
to me.
cleanup item.
I appreciate the explanation.
Any other thoughts, questions, or comments on the?
I do have one question. Is this intended to be non-party witnesses only? Or are you contemplating parties who may be witnesses?
Mark, let me go ahead and let you address that.
I think it's basically for anybody who is a witness, that
Okay.
is a necessary witness. They can be parties or non-parties, or you might have a fact witness who is remote as well.
And Chancellor Cole in particular, if you look at page 11 of 22 of the materials, under subsection Roman numeral 5, small letter 3I, you'll note that there's a breakdown between non-party lay witness and party and expert witness.
Okay, I see that. Yeah, thank you.
The rule, sure. So the benefit of this rule is that it does provide courts discretion, authority, and guidance as to the different standards that would apply between a non-party witness on the one hand and then a party or expert witness on the other hand.
Thank you.
All right, hearing no further comments, Lynn, can we go ahead and take a roll call vote on the motion for approval and adoption of the amendment to Rule 43.01A?
Sure. Kathy Clayton,
Aye.
Catherine Barnett,
Yes.
Brandon Bass,
Yes.
General Bloomstein,
Yes.
Bo Burke,
Yes.
Michael Carter,
Yes.
Mark Folks,
Yes.
Wayne Ritchie,
Yes.
Scott Sims,
Yes.
Sarah Key,
Yes.
Donald Caparella,
Yes.
Alan Wade,
Aye.
Doug Hallajan,
Yes.
Julian Kelly,
Yes.
Representative Lamberth,
Yes.
Alex Little,
Yes.
Tim Mickle,
Yes.
Gino Bolso.
Yes,
I believe I've asked all our voting members.
great. All right, the motion carries. Thank you very much, Mark, for your work and your committee's very hard work on this excellent addition to the rules, and we'll be pleased to pass it along to the Supreme Court for their review. Our next item on the agenda is a proposed rule or consideration of a proposed amendment to Tennessee Rule of Appellate Procedure 30. Kathy, can you lead us through a discussion of where your committee ended up on that rule?
Sorry about that. I was muted.
Okay, no problem.
When we were assigned to look at Rule 30, we were assigned to look at whether we wanted to recommend an amendment to the rule on forms of briefs and other papers, or add a comment. And the issue before us was that Rule 30 was drafted at a time that did not contemplate electronic filing. So when it talks about form of briefs and other papers, it talks about paper filing. And after discussion, we, and you can see this at page 15 and 16 of the packet. After discussion, we felt it was more appropriate to recommend a simple comment that says all appellate court electronic filings are governed by Tennessee Supreme Court Rule 46. And we do this as a stopgap provision, knowing that there's going to be more revisions likely in the future related to electronic filings, but we wanted to make sure that practitioners who were perhaps not as frequently filing appellate briefs electronically already knew that if they did file electronic briefs, that there were special formatting rules on that contained in the Tennessee Supreme Court rule. So having said that, I'll be glad to take questions, or just go ahead and nominate and make a motion on behalf of the subcommittee to accept the comment.
All right, we have a motion from Kathy for adoption of this comment to Rule of Appellate Procedure 30. Do we have a second?
I'll second.
Thank you, General Blumstein. We've got a second.
Yeah.
All right. Any comments or questions about the proposed comment to Rule 30? Hearing none, let's go ahead and conduct a voice vote. All in favor of the motion adding the one-line comment, quote, all appellate court electronic filings are governed by Tennessee Supreme Court Rule 46, close quote, please signify by saying aye.
Aye.
Any opposed? No opposed. Lynn, it passes unanimously, and we will forward this to the Supreme Court for its consideration now. Next on the agenda, we have item 5, a proposed revision to Tennessee Rule of Appellate Procedure 4A regarding relaxing requirements on the timely filing of a notice of appeal. Tim Mickle is going to lead us in that discussion. Tim?
Yes,
I'll turn
sir.
it over to you.
Yes, sir. Well, this proposed amendment came to us premised on a couple of fundamental concepts. And one was the importance and the recognition of parental rights under the Constitution and law, and just how important those are, the decision making that goes into a termination of parental rights, and just what a very important thing that is the courts do. The second thing why this came to us is because, unlike criminal cases where there is an ability to obtain an appellate waiver under certain circumstances as determined to be in the interest of justice by the Court of Appeals, there isn't that sort of bailout provision right now with respect to parental rights. And what we have found is that there are a certain number of cases every year where the parental rights and appeal is not perfected timely on a termination of parental rights case. And we looked at that, and some of the reasons for that seem to be that while the appointment of counsel is required in parental rights cases, there's no requirement that particular representation be effective under Tennessee law. And so we find ourselves in situations where there's a concern that perhaps folks aren't getting appropriate representation and appellate deadlines are being missed, and that perhaps that can result in a technicality that disallows consideration of what might be in the best interest of a child in an appellate court. And so the request was made that we look into perhaps putting some sort of waiver provision as that could be determined by the appellate court for timeliness of appeal in parental termination cases. And we discussed that. We had a very robust discussion about that. We had Justice Lee join us in that discussion because she, in fact, has authored the dissent in one of the cases in Tennessee where this was an issue. And so we thought she, of all people, had firsthand experience with how this can create problems in parental termination cases. But after a robust discussion, what we did find is that there were arguments on both sides of the issue. Those who would oppose the change would argue that finality of the trial court's decision basically is in the best interest of the child, and that there is an interest in finality. We did get some pushback from the Court of Appeals about amending the rule because they felt like administratively this would put another burden on them where they would have to decide and determine the issue of what would be an appropriate circumstance for a waiver. Now, the pushback to that was, of course, that is done all the time in the Criminal Court of Appeals under the waiver provisions that exist there, and that hasn't created a terrific administrative burden on the criminal courts. But in essence, at the end of the day, we went back and forth on it. We found that there were good reasons for, there were also good reasons against, and a good bit of resistance from the appellate courts themselves. And so we decided that although it was something worth considering, that ultimately we didn't believe that it could get the momentum that it needed to pass through the process, and that ultimately the legislature would probably take a dim view of it as well, because for various reasons. And so we just decided that while it was something worth considering, it ought to be tabled, and we decided not to make any sort of recommendation to the committee other than that we table the issue.
All right. Thank you, Tim. Does anyone have any thoughts or comments on the tabling of this proposed consideration of an amendment to Rule 4A of the Rules of Appellate Procedure?
Gino, this is Kathy. I agree 100% with Tim's conclusion and summary of what our committee discussed and ended up determining, but I also want to point out to everyone, if they have not had a chance to read the memo that Tim submitted, that we have also recommended that the issue of adding a notice be considered by the Committee on the Rules of Civil Procedure. So I don't know how procedurally we address that, but I just wanted to bring that up.
Yes, thank you, Kathy. I had let that slip my mind, but we did. That's exactly right. That we thought that there might be some sort of legend or something that could be added to the orders that go down in parental termination cases, just making it crystal clear that there is a requirement that the decision be appealed within 30 days of entry.
All right, and what we will certainly refer that to the subcommittee on the Rules of Civil Procedure to see whether adding that notice makes sense, and perhaps it'll be brought before us in September or at one of our future meetings. Any other thoughts or comments about Tim's presentation or the tabling of proposed amendment to Rule 4A?
Tim, this is Alex Little. I do have a comment. Or not Tim,
Yes,
Gino,
please,
I'm sorry.
Alex. No.
Yeah,
Go ahead.
I think sometimes we forget that we're appointed here not necessarily just to express our own views, but in part to help create the rules which bind, fellow Tennesseans. I think this is one of the rules where if you ask a general person on the street if this were possible, they'd say, no, that's absurd. If you lose your kids permanently, hire an attorney to file an appeal and they don't do it, there's got to be a way to fix that. And so I think that one of the things I didn't hear at all in that discussion was any discussion about, how the public and how generally the people involved in this process would perceive a rule that is so definitive. So I'm disappointed it's tabled. I hope we turn back to it another day.
Alex, can I address that? Because I didn't get into the weeds on this too much, but I will say that one of the things that the appellate court pointed out to us was that there is a mechanism, and I frankly wasn't aware of this. There is a mechanism, I believe under Rule 59 or Rule 60, where you can go in and ask the court, basically, I will call it, to freshen the judgment under particular circumstances in order to reinstate the 30 days for appeal. And one of the things that the appellate judges have indicated is they believe that that mechanism already exists under those rules. So there's no reason to create a particular opt-out just for parental termination cases. Now, I pointed out in our discussion that my experience with Rule 59 and Rule 60 is that that's a fool's errand generally, to try to get a court to reverse its ruling based on something an attorney has done. But in any event, that was one of the one of the positions of the Court of Appeals, and I just bring that to everyone's attention.
I appreciate that, Tim. I will say, I think with Rule 59 and 60, attorney error is not generally a ground for refreshing the judgment, renewing it, getting it restated. But
that's been my experience as well. So that's why I expressed some reticence on relying upon that. But it appears that the Court of Appeals disagrees with us on whether that would be an appropriate reason or not. So I just note that for whatever it's worth for practitioner.
Well, Alex, to your point, I'll say it's also hard for someone on the street to believe that if you're entitled to a lawyer and the court appoints you a lawyer and the lawyer doesn't do a good job and you lose your kids, that you are not entitled to a competent lawyer.
I had that exact thought, but I fully agree.
That's just my personal opinion.
When you're entitled to
rule
chat
that can-
GPT as a lawyer.
But that's the way we work here. So, but your point is very valid.
Hey, Gino,
Perhaps
if
we
I
could-
may.
Go ahead,
This is William,
Leader,
real
sure.
quick. So I think the analysis of kind of the legislative perspective on this is a sound analysis from the committee. We have tried very hard to make sure over the last several years to change our statutes so that it is the best interest of the child. No one is losing possession of their kids. There's not an ownership interest. They're not property. These children are languishing in the court system anytime for years and being bounced from foster home to foster home. Finality in the best interest of those children is important. It is their best interest that we have tried to put paramount and at the absolute forefront of all consideration. Parental rights are extremely important. Competent counsel is critical. I hope our judges keep it in mind when they are appointing these attorneys, because if they're not appointing competent counsel, they're doing everyone a disservice. And that's a larger issue we should all look at. But it is the children that we are looking at least from the legislative perspective, first and foremost. So just for purposes of conversation on this, I appreciate the committee tabling this as their recommendation.
Great. Thank you, Leader Lambert.
Valid point.
Any other final comments before we go on to the next item?
I said I would not stir the pot, so I'm not going to stir the pot.
Okay. Thank you, Chancellor Cole. Appreciate the lack of stirring. That'll take us then to item number 6, regarding residual funds, otherwise known as found money. So Elizabeth Ryan, can you walk us through number 6, excuse me.
Elizabeth,
I know, I was having trouble getting my cursor over to this. Just give me, my cursor is giving me problems right now, so I can scroll down. So this came to our attention in the court. As you all might recall, there was an article in the paper recently about a certain lawyer who was using residual funds really for personal benefit. We do have provisions already in the rules of civil procedure for residual funds. and the disposition of residual funds. Jeff Zager and I spent some time. Jeff actually did a lot of the work on it, more than I did, so he may want to speak more to it. And we looked at other states, how they handle their residual funds. And so what we found was that the majority of states direct where residual funds after a class action, that are left over from a class action lawsuit will go. We didn't really have so much direction in our rule. So we really kind of looked at a lot at how other states do it. Some of them will fit in a bar foundation fund. Some will, allow it. Generally, it has to go to something related to the subject of the class actions of the lawsuit, but something to go towards helping indigent indigent litigants in civil cases. That is limited to civil cases because this is generally only coming up in a civil matter, or is only coming up in a civil matter. So we kind of cobbled together what we thought was the best language from around the country and other states' rules to kind of restrict how residual funds can be used. And to use it to the best ends of in the civil justice system. That's really where we got with it. Do you have anything you want to add to it?
Sure. Just by way of additional background, in case anybody did not see, I think this came up in the Knoxville press, involved a lawyer probably well known to many of you who does a lot of class actions and was acting within the scope of the existing rule, was not doing anything that was technically improper, but was getting the trial judges to approve distribution of residual funds to go to charities of his choice. And oftentimes his name would end up on whatever the funds were used for, whether it was a building or something else. Which, personally, I'm not going to speak for the court. I personally found that very distasteful. But it also just raised a concern about what was happening on a more broad level with the residual funds. And in looking at this, there were about 24 states, which predominantly through their rules of civil procedure, a few by statute and a few by Supreme Court rule, regulate the distribution of the leftover funds from a class action where, for example, people don't make a claim on the funds and their funds left over. And it can be substantial amounts of money involved. And the majority of those states specified that a percentage of those residual funds go to some sort of either bar foundation, legal aid, access to justice, anywhere from 25 to 50%, and that the remaining funds also go to that or may go to something that is more directly related to the purpose of the class action. So if it was some sort of consumer protection class action, they would be directed towards organizations that fostered that interest. And so, as Elizabeth said, we took a look at the states that did this by rule, since we already have a provision in Rule 23, and the language was fairly uniform among those states. And we tinkered with it a little bit and came up with what we hope is a proposal that will still allow a bit of flexibility, but also prevent the funds from going to something that has absolutely nothing to do with the justice system or with whatever the class action was intended to benefit.
I'll add one more piece of background. So this rule came, it's a relatively new rule for us. I think it came in around 2009. Frank Buck was on the Rules Commission at that time and was responsible for bringing this to the Rules Commission. Then Jeff and I went back and looked through some of the historical documents from the Rules Commission back then. Did not find anything to indicate why it was written the way it was written then, or if any of the discussion that happened around the committee with the rule then, just in case that is a question anybody has. So about why ours looks this way versus what others look like. So.
All right. Well, thank you, Elizabeth. Thank you, Jeff. It strikes me as a stroke of genius to use residual funds to increase accessibility to the civil justice system. That makes perfect sense. And I'll just ask anyone whether, before we formally refer this to the subcommittee for civil procedure, whether anyone has any comments they'd like to make about this proposed revision to Rule 23.08.
Elizabeth, this is a question related to just the way that the proposed revision is written. So it says there at the bottom under the red line that there'll be an order that shall provide for the disposition or disbursement of these funds. And then it says not less than 50% shall go to the AOC through that process. So is what we're saying there that not only must the order provide for the way that residual funds are going to be dispersed, but that order must also say that 50% goes to the AOC. Is that what we're intending?
Yes.
Okay.
Yes. And that's obviously the AOC is going to have to use that, as it says, to support activities and programs that promote access to civil justice. You know, the Administrative Office of the Court administers funds for the Access to Justice program. They also, you know, administer funds to other organizations that work, you know, on that behalf or to that end across the state. So we wanted to be able to not necessarily direct it to a certain entity, but to where it was needed, and with the ability of the AOC to have that flexibility to see where its greatest need was at the time. So
yeah, and my question is not really related to the, you know, that not being a good idea. I just wanted to clarify that what we're saying is that every order resolving a class action under the state rule has to provide for the disbursement of those funds, and then it must provide that 50% of those funds go to the AOC. I was just mainly clarifying that that's the intention.
Yes, it is.
All right, we will refer this to the subcommittee on the Tennessee Rules of Civil Procedure, and I hope have something to present to the commission for a vote in our next meeting in September. Item number 7, the next item on our agenda, deals with expert testimony. It's actually something that has come up a number of times in my practice, likely in that of many of you as well, because in Tennessee, you might have 2 different types of experts in a case. One who is specially retained simply for purposes of expressing an opinion in litigation, or secondly, this category that's called an actor-viewer witness. That was explained in our Court of Appeals decision back in the early 1980s, I believe, in Alessio versus Crook. And disclosure of those 2 different types of expert witnesses is handled differently between our state rules and the federal rule. Under our state rule, 26.014, there's only a contemplation of a disclosure concerning a person who has been retained in anticipation of litigation. And the rule does not expressly address whether and to what extent there must be a disclosure of these individuals who might be considered actor-viewer witnesses, such as a physician, perhaps, in a personal injury case, or a financial officer of a company in a case involving accounting or other economic issues. In the federal system, as many of you know from your practice there, there is a 2-tier type of disclosure under the federal rules. One, you have experts who must prepare a report, and that is what's considered to be a specially retained expert for purposes of a case, what our state rules call a person retained in anticipation of litigation. And then there's a second category in federal practice, experts who do not have to provide a report. And those are these classic actor-viewer witnesses, folks who have expertise and opinions to express that fall under Rule 702 of the Federal Rules of Evidence, who, for whatever reason, are going to be testifying, but were not retained, and especially simply to express an opinion, but who were part of the underlying facts. And I've had several cases where, perhaps for lack of a better term, trial courts have become confused as to whether an expert falls into one category or the other, and is sometimes asked to exclude a witness's testimony because there was no formal disclosure under Rule 26.01, subsection 4. And so it occurred to me that we might be able to resolve some of the confusion that arises from time to time, either by adding a comment to Rule 26.01 about whether and to what extent there is a disclosure requirement for active viewer witnesses, or perhaps amend the rule itself to provide this two-tier type of disclosure that we see in Federal Rule 26. So my thought is that we refer this issue to the Subcommittee on the Rules of Civil Procedure to analyze it and perhaps report back to us at a future meeting as to whether there really is a need here to provide more clarity to trial courts on this concept of an active viewer witness and the disclosure that might be required thereby. So having said that, I'll just open it up for other thoughts and comments about whether this is something that the commission believes we should investigate.
Gino, I deal with
Hey,
this
Brandon.
regularly. Thank you. I deal with this regularly in practice. As you mentioned, treating physicians are a core part of many personal injury cases. So it's something we often see. There are ways for litigants and litigators to best protect themselves and protect access to essential witnesses. But right now, there's both a great deal of discretion and a great deal of potential for confusion, as you described. So a solidified and guaranteed process to make sure that everybody on both sides of the bar have access to all the information they need about who's going to testify, and that there's no surprises, particularly at the 11th hour. There's nothing worse than for anybody involved in a case, from the parties to the court, to have the pretrial conference dictate a major swing in what the evidence is going to be over allowance of experts, just because of the framing of an expert disclosure to try and match to guess at what how a witness might be characterized. So I'm all in favor of investigating whether and how much to mirror the federal process.
Great. Thank you, Brandon. You bring up a great point that, I mean, the bias of our rules should be to encourage disclosure so that we've got no surprises at trial. And so everyone has got equal access to information to prepare the person's case to be presented to the court or to a jury. Any other thoughts or comments from commission members or members of the judiciary? All right. We will go ahead and submit item number 7 to the Subcommittee on Civil Procedure for their analysis and perhaps recommendation at our September or December meeting later this year. Turning then to item number 8 on the agenda regarding Rule of Appellate Procedure 42. Jeff Zager, can you go ahead and lead us through that discussion?
I can actually. I think it will be very brief. This was the issue that came up with mandates and the problem with mandate issuing after the Supreme Court denies a Rule 11 application and providing time for petitions for rehearing. The short answer to all of this is that when we started to look at this in more detail, it became clear that the rule as a whole needs to be revamped. There were a lot of other issues that came up in our discussions with the clerk and the clerk's office and amongst the court and the court staff. So the decision was made, or recommendation was made, that we back up, essentially, I guess, maybe table this, refer it back, and let us look at the rule in toto and look at doing a complete revamp of the rule on mandate.
All right, and I understand from your memo that this is something that the Subcommittee on the Appellate Rules has assented to taking up and giving some analysis to?
That's correct.
All right. Before the Appellate Subcommittee gets started on its work on Rule 42, does anyone have any comments or thoughts about Jeff's presentation or the memo? Wonderful. That'll take us then to item number 9. Michelle will give us an update regarding the clerk's office requirement to maintain a numbered civil docket. Michelle, can you walk us through that?
Sure. This will also be fairly brief. Some of you may recall that this discussion came up, I think it's been over a year ago now, for the need or just desire to have a consistent civil docket within the clerk's offices. I know Aaron Hall had brought it up. I don't believe he's on this meeting today, but we had continued to defer it because it got tied up in discussions about possible changes or creation of e-filing, electronic filing across the state, in which the administration and the legislature have been involved with. And I'm extremely happy to say that this year, because of the governor's work and the legislature's gracious appropriation to this, but there was an appropriation in the budget this year for $75 million to look at and start the ball rolling for statewide e-filing. And in that, with that 75 million, that there is a effort and a whole host of people who are involved, including the clerks and all the other affected entities that are meeting to determine the exact ways to implement that across the state. So any uniformity with civil dockets that I know this group had talked about mirroring the federal system, that would be tied up in that entire discussion. Jim Hibner obviously on this call as well, he is chairing a technology oversight committee that the Supreme Court has appointed to look at all this and look at all of the different counties and case management systems, everything that would tie into an enterprise e-filing system across the state. So this is a hugely positive development in a direction to really bring e-filing to Tennessee, just to have it uniform across the state. But we're in the beginning stages of that now that we do have a significant appropriation for that purpose. I think we will see things move fairly quickly. I definitely want to thank Gino and Representative Lamberth. I mean, they're huge advocates, on behalf of this for the entire judiciary. So it is definitely exciting development. But for the purpose of the civil docket discussion, I would recommend it just be tabled for now, because any update to that would come in would coincide with this enterprise e-filing development. So that's where we are.
Great. And I'll simply emphasize what Michelle has stated, that I think this is really going to be revolutionary in our practice in Tennessee, because not only is electronic filing going to be universal, but it's going to be unified. It's going to be the same across all the states, across all 95 counties, and will, I think, do volumes to increase accessibility to the system, provide efficiency, and reduce cost. So kudos to everyone involved in making this happen, including everybody, obviously, in the executive branch and the governor's office for making the suggestion. And obviously, it got passed by both houses of the General Assembly and is now signed into law. So do we have any comments or thoughts about item number 9, the new $75 million appropriation to provide electronic filing in a unified way across the state? All right. Well, that will bring us to the end of our agenda. Our next meeting of the Rules Commission will be on September the 8th, the second Friday in September, once again at 9:00 a.m. And as all of you know, we will have a different Supreme Court in September, because Justice Lee's retirement becomes effective now at the end of August of this year, August 31 of this year, and will be replaced by someone who's got very, very big shoes to fill, our good friend, Justice Dwight Tarwater. But Justice Lee, on behalf of myself and the commission, we can only thank you in our poor way for all of the guidance and help you provided to us over the years, and your invaluable service to the citizens of Tennessee all these years in the judiciary, and most specifically on the Supreme Court. So before we sign off today, Justice Lee, are there any additional comments you'd like to add, given that this will be our final time together with you as our liaison to the Rules Commission? Is Justice Lee still with us?
Hey, Chairman Bolso, while we're waiting for Justice Lee, can I just make one quick comment?
Yes, please, Jim, by all means.
So not to discount the most amazing justice ever, but we also have Jeff Zager, who is actually retiring at the end of June, and he won't be with us going forward either. So, and he's been extremely helpful on this commission and as a member of the Supreme Court staff attorneys staff. So thank you, Jeff, for all your service as well.
And let me echo that as well, Jeff. That's unbelievable that you've actually reached the point where you're old enough to retire. I never really thought that that would come to pass because we're somewhat contemporaries and have been working together for many decades here in the legal practice in Middle Tennessee. So congratulations.
You know, you
to
have more
Job
stamina
well
than
done.
I do. That's all I can say.
Well, it comes from having Caparella drag me around the tennis court from time to time over the years.
Well, it's been a privilege to work with the commission. It has been it's a vital to the work that the court has done and continues to do. And it's been very fulfilling part of the job here as a staff attorney and a great opportunity to work with lawyers that I didn't get to work with in my private practice. And we're on behalf of the court, most appreciative of what the commission does. So thank you.
You're very welcome, Jeff. Any other comments from anyone before we adjourn?
Hey, Gina, this is Michelle. So Justice Lee is having technical difficulties and she is apologizing profusely that she cannot talk right now. But she really thanks everybody for the comments and she's enjoyed her time, working with this commission, but she is extremely sorry. She heard everything that was said.
Okay. Thank you all very much. I will declare us adjourned and we look forward to seeing all of you again, 9 o'clock in the morning on September the 8th. Thank you all.
Thank you, Gina.